right, away we go. As we wait for court to return from their lunch recess, we have questions and answer session here where we're taking your questions and they're coming across on our YouTube channel. So let me go with try to piece a couple of these together. So I think it's Bryn West from YouTube. Ladies asked the following question. What do you think of attorney Brian Steele? That's the defense attorney. And Tallgrass again from YouTube asked the question, what is your opinion as to which was better, the state opening or Steele? So Bridget, let me start with you. What do you think generally is Steele's opening? I think most lawyers would say it was a lengthy one, not that there's a time limit on it, and it was very detailed where defense attorneys typically don't do that. What are your thoughts?
Well, I mean, I think you summarized it very well. It was extremely lengthy, but this is going to be a very lengthy trial. And so he is trying to get ahead of the state's case in chief. This is the time that Mr. Steele has to present all of his evidence before the state brings their case in chief. In any trial, the state gets to go first, right? So they bring their case in chief, and then the defense has their opportunity to bring their case in chief. But prior to that, this is the opportunity for him to lay out specific instances and say, well, this is what the evidence will show. This is what we anticipate will be happening. And so he's going through those things very carefully and explaining to the jury, this is what we anticipate will be coming up in this trial. And he's also trying to explain it to the jury. This is the reason why this happened. This is why this happened. This is what is being considered an overt act. This is what the state is saying, you know, is really tying Young Thug to this racketeering charge and what is not. And so he's trying to explain to the jurors, well, these instances really shouldn't be tying him to these charges before the state has the opportunity to say, these are the instances that tie him to this charge.
Yeah, and so I just want to get into that and just follow up with you on that. You know, a lot of, there is truth. You have to tactically do things differently in each trial. And while defense typically doesn't have, it has no burden. It doesn't have to even give an opening statement. And then typically they don't give a very detailed one. I like the idea he came out forcefully and was attacking the prosecution's case, because we all know the opening is the most important thing in a case. It's where the jurors start to formulate their mind right from the beginning, and he needed to counteract that. So let me follow up with the question, do you think that when you balance what he did here, did he, in your mind, do a better job than the prosecution did in the job? And I'm trying to look for who one of these people, one of the folks here asked this question. And let's go to Maisha from YouTube, because she asked this question: do you think these extended opening statements hurt or help the prosecution? We haven't been able to pull the pieces together yet, and it feels overwhelming already. Bridget, I'm going back to you, because as a trial lawyer, if I'm a prosecutor and one of my people is looking at this and they're telling me when I go back into my office that Maisha is saying that she feels that she doesn't have the pieces pulled together and the opening statements are really long, I got the burden of proof. I'm nervous as a prosecutor when I read that question.
Well, I mean, that's true. First of all, a lot of people don't have a very long attention span. So we start there. We have to make sure that we start out the gate getting the jurors' attention. And so, but the issue is that in this type of case, in this racketeering type of case, there are so many moving factors. The state alone is projected to bring over 400 witnesses. And so when you talk about that, there's no way that their opening statement is going to be 10 minutes long. That they can't cover everything that they need to cover in 10 minutes. They have to at least go into some of those specific details to show this is where we're going to be going throughout this trial. It's kind of like a roadmap. And so they are trying to set that precedent to show the jury, okay, this is where we're going. Right. But the issue is that it's difficult for individuals to follow that. But as they continue to go out throughout that trial, they'll be able to reference back. Well, remember an opening statement I said this this was going to happen. Remember in opening statement, we talked about this and that the evidence wasn't going to show that. That's what they're doing. They're just planting seeds. And so that way, when we get to the trial, they'll be able to say, well, I talked about that in opening statements, and each of you promised to follow the law.
Well,
and so that's what they're doing.
I'll tell you what, Miesha, if I were to read this, that you haven't been able to pull the pieces together yet, and it feels overwhelming as a prosecutor who's got the burden of proof, of proving a case beyond a reasonable doubt, I'm nervous I didn't put it together in a way that the jury understands. I'm just saying. Let me go to you, Sonny, on this one, because it was some tall grass again was asking which, in your opinion, was better, the state or the opening, and I want to caveat this, because what does better mean? Well, we go to Miesha there, and I'm kind of moving around with people's questions. If she's a little overwhelmed and she doesn't know if they're putting it together, I don't like that from a factual standpoint for the state. But I'm going to give you another one. I'm not sure if you saw this, Sonny. There was an issue where the prosecutor in the opening statement, in my mind, got dangerously close. In fact, I think, at least from New Jersey standards, it would be an appellate issue of monumental problems in burden shifting. When the prosecutor's saying, you're not going to hear anyone from my case, say that they were in a gang or something to this effect. But, where's the information coming from? Otherwise, you're not going to hear that it's not true. In other words, saying, and there was an objection at that point in time, that there was burden shifting that went on there. You never comment on a defendant's right to remain silent or anything that could be inferred in a defendant's right to remain silent. So to answer Tallgrass's question, at least from where I come from, is I got Miesha over here who's a little bit overwhelmed in not knowing what the facts are, and I got a prosecutor who, in my opinion, created a matzo ball of a major legal issue right in the beginning of the case. That was very amateurish to me, which I would imagine this is a sophisticated and experienced prosecutor. Thoughts?
I agree with your assessment, and also being from New Jersey and starting my entire life out with New Jersey criminal law and how things unfold, a prosecutor should never ever make that type of mistake, because that also sits in the minds of a juror. Oh, so the defendants might not testify, they might not be able to say this. All of those factors play into, as you said, a potential appellate court decision and the defense counsel having to object. These are crucial moments, and this is a RICO case. This is not a small case. I also heard the defense attorney really lay out some nuggets about law enforcement, due process, and everything that, may come into question. So I think it's really important that burden shifting never happen, and that the jury is also paying attention. Now, Miesha might not have the nuggets all put together, and the roadmap might not look like it's going straight, but that might be problematic as Miesha and others, I should say, continue to listen to the case and say, well, wait a minute, the prosecution said this in defense. Yeah. It caused an objection, and will this somehow be problematic later?
Look, at least where we come from, it is drilled in our head as prosecutors. Drilled. Don't say anything that could even possibly, in 1 million connective points, be perceived as burden shifting or commenting on a defendant's right to remain silent, because even if the prosecutor didn't mean to do that, at least a conservative appellate court, or a liberal, I guess if you want to say, like in New Jersey, love to reverse convictions because they believe prosecutors went over that sacrosanct line. It just is not necessary to throw into a trial. Okay, we got one more before we had to take Bridget. This is a great question. It's from Ashley Perry from YouTube. When we have a witness on the stand, will each lawyer cross-examine for their defendant, their client, or are there certain witnesses that only pertain to one person?
That's a very good question, Ashley. So whenever there is a witness that comes on the stand, there may be where the defense counsel for Young Thug, he decides that he wants to cross-examine this particular witness, and then the other counsel, if they choose to, they can do so. And so it is up to them if they have questions that they want to cross-examine this particular witness about. The state has provided the witness list to all defense counsel, and so everyone knows knows who's going to be coming up or can potentially be coming up as a witness. And so they should be prepared for cross-examination on any of those witnesses that may be coming up in this trial.
Yeah, I could tell you as a trial trainer, Ashley, that every lawyer has a right to question every single witness that comes on that witness stand. That is a great question, but a really good nuanced question is just because you can, ladies, you know this, doesn't mean you should.